It's not only about creativity, but there is also one important issue. We talk about legislation. We will talk with lawyers from Skolkovo, and they will share the packages that you need to have, how to have these contracts which are correct, how to have patent, what are the analyses that can be, how to protect your rights here in Russia and abroad, and what are the potential services they can provide, how you meet legislation, how you create contracts, what are the benefits that can be. So there are a lot of important information. I'm really glad to introduce our speakers. We have here Jeanette Abduraimov, the head of Intellectual Property Department, and colleagues. Hello. Thank you for this great invitation and introduction. We are really glad to meet the colleagues, participants of Startup Village. We work here together for you. So let's talk about services that we have at Skolkovo. We have lots of services, but the one that we present about Skolkovo, these are judicial services to protect startups. I would like to talk about two programs that we launched and they are successfully implemented. This is a comprehensive support from our lawyers. This is for startups, for the companies who are part of Skolkovo infrastructure. We have approximately 3,000 companies. They are located in all regions in Russia. These are legal entities. Skolkovo, it's not just a territory. This is the ideology. So we work with companies who are placed here in this territory and who are located in their cities. These are 3,000 companies. They go through different procedures. They create their companies, and they have multiple issues that they face. So the first program is IP Protect Pack. It is about intellectual property, and another program. This is more interesting for startups, and legal toolkit. It is interesting for partners. We will talk about it separately. These are two holdings, corporations. They are also here in Skolkovo, and they are participants of these processes. They have the same benefits that our participants have, tax benefits, and within the framework of our work, we protect intellectual properties and we provide such services. So the first, we'll talk about IP Protect Pack, and then we'll talk about legal toolkit. What are the elements of this? So IP Protect Pack, it's a program, free program developed for Skolkovo participants, for startups, but it's not only limited to the companies who are here in Skolkovo, but to all the companies who are part of this infrastructure. It's about intellectual property at all the stages of your projects. Usually there are issues, how to protect it, how to protect information, how to be competitive, and how to avoid different issues when competitors, for example, want to copy your project. So what is required? It's about investors also, how we attract them. It's about objects that you have, how to have documents in place. This is the program that we launched, so you have all access to all the documents, to the best practices, so you understand that we here talk about the quality that we support, the best experts can share their knowledge. And within this program, we have a number of events. It's not just consultations when we answer your questions, when we provide different samples of documents, when you have access to webinars. It is a complex solution, and we talk about it in details. And in the future, if you need separate events, we can agree to hold these events. It can be done with grants. You can receive financial support from Skolkovo. So we work on it so you don't have any headache. I will talk about our center in a few words. If you don't work with us, so the Center of Intellectual Property, we provide legal and patent services. We have more than 30 legal experts who are focused on the services. We, for example, have colleagues who work with EMCG, with medical facilities, and we are leaders among participants and requests. We have lots of positive approved solutions, and we can guarantee that you will achieve the results that you want. And the guarantee is 98%. We are the only office. We have here the International Office of Intellectual Property Protection. This is an office part of UN system, and they work with different patents, with documents. This is what we do today. We are the only country where in Eastern Europe you can find this office. So please come to us and you will receive a high quality expertise. We will answer all the questions on legal issues. So what is about IP Protect Pack? We will take you through all the steps. We will follow you throughout the journey of your project from the idea. We know that idea is always the main step, and then intellectual property issues. Sometimes it is the result of R&D activities. R&D can be included in the contract. It is legally approved. We have also confirmation of your work. So we work with R&D, with special individual activities. Well, sure, it's about 1225 law. This is the number of objects that is enlisted there. So what is critically important to be done? Because this is intellectual property made by human, we need to understand how to list people involved, also who work as an outsource. If you are not only the founders who are involved in this project, then there is a legal scheme. It can be an option with shares, and at every stage of your project, you can find necessary personnel if you need. You can also receive bonuses, benefits, if you increase the number of members, if you need the tools. So you can expand your project and you can realize that everything is in place. How to register intellectual property? It is actually a very difficult process. It's not only about requests that you place. There are some business models that have licenses. They have other documents. It can be an open license. What is the best model? Whether it's patents, know-how, or copyright, we can talk about it later. The next aspect is about investments. Usually after we talk about team members, after you have your pitch, when you talk about your projects, it is really important to understand who are within this team. And then what is with your IP? If you do something and it's not really unique in terms of intellectual property and can be copied, you don't have lots of prospects. If you want to have your intellectual property protected, you need to follow the steps. Otherwise, you will be copied. And investors, they will not really like it. They want to understand that everything is protected. So people who are enlisted in this project, they should work on this project because startups, these are legal entities. We need to realize what are the shares, who are co-investors, who are partners. When you talk only about founders, it's not that you can attract investment. Then you can transfer the rights, and then it can be a legal, judicial, or it is a foreign market. So how to check whether your brand name is unique or not? Well, usually you invest lots of money into marketing, into media coverage, and sometimes you can find out that this brand name is not unique or it is identical with something that was on the market before in this sector, in this field. And then you have these issues, you need to do something, you need to overcome these problems, so you need to think about it in advance. The brand name is what you can really use. When we talk about patent, sometimes it's a headache. You need to realize whether it can be valuable here or it is taken into account in other countries. Well, scientists sometimes think that it's just the step that you can miss, but they do not understand the force of this patent. We will talk about it, how to do it, in which countries, what should be patent, and what is better, patent or copyrights. We'll talk about it, why know-how is not what published and it's not registered. So why it is better or not better than patent? It's not that you usually need to have patent. Some people follow know-how model, but if you have reverse engineering and you can have this product, you can realize what are the parts of it and you can use it. Sometimes it's something discrete and you are carefully working with know-how or you work with a commercial aspect, but you should understand how to work with know-how. Copyright is about intellectual property. It's usually about RVM programs, IT companies, then we have biomed companies. They can protect their projects. They have this intellectual properties protected, but there are specific issues when you register patent and you go to the special offices, when you go to notary offices. It's not really the support that you probably need to have. You need to understand all the elements. So we work with you. We can share all the necessary information. What is important? Well, we'll talk about patents. There is no international patent. In every country, you need to have a separate patent, and you need to understand what is the country you will work with, what is the geography. We will share the information about these countries and how to be prepared for the IP due diligence. If you are on the market for a specific period of time, then you try to do due diligence. This is the check from legal aspects when there is a check and they try to evaluate all the risks. But why is it important? It is really important when you have specific contracts. Investors, they want to see this due diligence, so these agreements are not cancelled, and it is important to be prepared for this due diligence. How to then access intellectual property? Jeanette will tell about this. With these assets, you can increase the value of your project. Many people, they don't understand what it is. They think it's just an accountant's information, so lots of issues are involved today. We will talk about the main aspects the main problems and mistakes that companies do. So now ask Jeanette to talk about it. She will answer the questions how to protect your intellectual property and what is the first step. Good afternoon. I'm really glad to see you today. So let's talk about intellectual property, how to protect it. Sure, with our help, you will be able to do it. But what to start with? Anton has mentioned the idea. It's not about patent idea. It's not about intellectual property. It's not the result of intellectual property, first of all. According to our legislation, we need to have material things. So when we have this project feasible, then it can be protected. It is something, it is the result of intellectual property of humans. It can be equal to something that can be protected, but in this case, we shouldn't forget. Now let's talk about Zuckerberg, all this legal issues that they had, and we can say that this legal now aspects and mistakes are still because people they argue who has the rights for this social network. We can say that it's just a hype, but still you should realize that the idea it was not intellectual property. You need to realize that when we have an owner of the project, of the startups, there is the head of the project, there is an inventor, and he needs to make this feasible, then there are third parties. It can be somebody like developers or outsourced personnel who create this platform, who can write out this code. For example, IT solution. It is important to understand what are the property rights between these people, because you understand who will have the rights for this feasible product. When we talk about this contract, for example, the contract of author's right. So you have a person who asks for special services, and then if I require these services, it's true that by default the rights are on my side. But it is quite difficult usually to write down in the contract what is the result that you want to see. When we develop IT projects, IT platforms, developers, when they want to create the solutions, there are some new objects of intellectual property, and they are created as part of this initiative. Usually, we have these situations when developers they do not share the whole information, and startup owners they don't know about additional functions. So as part of this agreement, you need to take it into account. They are special results of intellectual property, so you have to take it into account, and we can provide support. We can create all the necessary documents if you have personal part of your team. There should be a special NDA agreement among people. People should understand what are the results of intellectual property and why is it necessary, because according to the Russian legislation there is a norm. So all the results of intellectual property which are created within your task, they are belong to the owner of the company. But there is a special timeline, and you need to notify that there is a special time to register this read, and if this timeline is not met, then your staff who created this read, they actually can go and submit an application for property rights, and it will be reveal legal norms. So there are lots of issues like this. There are lots of issues in terms of legislation. And here we can provide this support. We can create all the necessary agreements. All the possible events are taken into account, all the possible conflicts with your staff, all the labor contracts, NDA contracts, call time contracts. This is how you need to start protecting your project. And then you can develop all the necessary aspects. So when we have specific result of intellectual property, we evaluate your projects in terms of objects that you have, because lots of people they don't know. For example, software, it is the same as literature, and based on your approach, it can be registered. But the software for computers, it can be the number of algorithms, it can be a code. But if it's just a code that is as identified materials, it can be something as an application to your platform. It can be a website. So here we can say that this is an industrial example because there is a designer solution, and lots of people they don't know that this interface of the website, this interface of the application, it can be protected with a patent. It is a patent for industrial example. So this is algorithm, these features that your IT solution provide, it can be also protected. It can be protected as a solution or some innovation. For example, blockchain, we had different patents. It is as a measure of sales, as a measure of speeding up different contracts. It is the object that can be patented. And when we have this analysis from our side, we can say that there is a program for a computer that can be registered at Rospatent. We can see the interface or your website. We can say that there is a unique device or unique solution, and we can provide support for this patent. I would like also to know that we have one services. This is a track services, the way you register your software as part of the software in Russia. It is really important to identify that this software was created in Russia. You will have special benefits, tax benefits. So now let's talk about the next step. We analyzed your project, we realized how to protect it using patent, using different documents, and then when the project is just created, it should be named. Well, it is a closed circle. I talked about it in details. So now let's talk about the name. So I mentioned that the next phase is when you want to give it a name. When you create any innovation or project, I usually work with startups. There are lots of people who have just ideas, and we don't see any results from this intellectual property, but they already know the name of this project. And usually, it is the first thing they talk about their name. But this name, brand name, it is a strong tool in terms of intellectual property. We can say that it is what we call a trademark, and it is a strong tool for every startup, for every project. It can be an innovative idea that will be protected through patents and will be monopolies. But first of all, it is important to say that this is for 20 years. It can be up to 25 years for pharmaceutical companies, but this trademark, it's not limited. So you can prolong it after 10 years and you don't have any limits. So patents, it have specific cycle, and usually it is for 10, 12 years, then this technology is outdated because we have competitors and we need to offer something new to our consumers, but still we have this brand. Brand, it is your trademark, which will live forever. So this trademark, it is a strong tool, and you need to be careful about it and to think about it in details. And what is important, we want to choose a name and what can be done. Usually we have startups with the names that they want to have, but usually when they check it on their own using Google Help, they just look for these brand names using internet and they can tell, well, I didn't find something similar. What is important? The search tools that you have, it is not enough. It is just 20% of what you need to do to check your brand name. You need to do it carefully, and we provide such support. We can provide solutions. We can tell you whether there are different trademarks in different countries. What are the trademarks that were registered? What are the trademarks that are popular? What is the region of this trademark? So we check all the bases that are actually closed to people here. So the third parties, they don't have access to this data. So only these companies like we have access to this databases. And at the end, we provide not only the analysis of search tools. We don't just say that there are similar trademarks, but we have 11 features which we take into account. We follow the law. Please take it into account. 11 aspects to register this trademark. Usually, when you want to register the trademark or a brand name and you think that is a great name, well, maybe it's not registered because there is no anything similar, but because there are some moral aspects. Maybe there are some words that cannot be used, some jargon. Sometimes people, they like to use some jargon and they feel that if they use it, then it's okay to use it. Well, it's not the right approach. For example, such words as IT, technologies, it cannot be your trademark. You need to take it into account. You should have a specific approach when we talk about these unique features. You need to work on it, you need to check it, and then you need to talk with specialists and you need to submit then the request for your trademark. When you want to register it on the international level, there is a Madrid system, international system, which allows us, with the support from international organization, to submit such requests. We can send it to the Geneva office, so they take these responsibilities and they can share this request with other agencies. It simplifies all the international procedures for registration your trademark abroad. It makes it cheaper because you just pay for one duty. Sure, there are additional duties based on the country you work with, but these are minimal duties. So you need to take into account how you register your brand name abroad, and you need to compare all these aspects. You need to realize how you name yourself in other countries. It is also the property aspect. It's not a very strong tool how you position yourself. You are as LLC Skolkova, for example, you have the right to be here on this market, but as an individual measure, it cannot be used. It cannot be a strong tool.
Because first and foremost, you cannot redirect your license and your trademark. The trademark is the name of the company that is the name of the company is present in the bank details, in the company details. So basically, you work with your company name and the trademark. So if you have any questions, dear participants of Startup Village, you are welcome to ask them in the chat, and we will do our best to answer your questions. Now you know where to start, why it's important to check the uniqueness of your company name, of the trademark. And let's talk about what you need to know about patents, what to consider about in this area. I give the floor to Maria Pustavalova. Thank you. So talking about the patents for industrial samples, for innovations, there are many forms of registration. In this sphere, we are going to talk a little bit more about the patents for industrial samples. That deals with the interface, with the parts of design, the design for any of your device. It can be protected by a patent for industrial sample. What you need to know about samples, they have to be unique and original. And let's talk in more detail about inventions. I will say a couple of words about the things you need to know in order to patent, to license your inventions. What is an invention? Invention is something that has some feasible technical result. It solves a technical task. Talking not only about the equipment or machines, but we also include here the solutions that are aimed to solve some issues or problems. And this innovation has to be a unique solution to a certain problem. It's important to know that only devices can be patented as so in the pharmacology, the patents are valid for 20 years, whereas the patents for useful models are only valid for 10 years. However, you should consider more requirements. First of all, it should be novel. It's crucial that any publication can be an obstacle on the way to getting a patent. Which could be quite a surprise. for researchers and innovators. So publishing an article about something can be an obstacle. In Russia, from the date of a publication until in application for a patent, 6 months lag is available and approved. In the United States, this time frame is bigger, from 10 to 13 months, but you'd better take no risk in this field because there aren't any benefits or exemptions. So if you disclose the information about your technical solution before you have a patent, because you may lose the right to obtain the patent after the publication. The patent agency can check all available sources of information, including the internet, anything. I know that young scientists look after as many publications as possible, but that's not a very good idea. As for the industrial samples, they include design. So if we're talking about the technical solution, that's definitely not a design that's going to be a useful model or and not an industrial sample. The advantage of an industrial model is that there are less requirements and restrictions applied to them. That's only the novelty and industrial applicability. The disadvantage is that that patent will be valid for only 10 years. As for inventions, they undergo even more requirements. Another a crucial criteria here is the level of invention. That implies that your invention should not be obvious for specialists from the field. This criterion is most frequently debated and challenged. In the patent agency, this criterion is assessed quite often and quite closely. In order to obtain a patent. Another issue is whether to patent or not to patent something. If your company requires a mandatory registration and disclosure of the type of activity, which is quite often so in pharmacy, that is quite often you have to disclose the formula of and the components. So all these have to be patented in advance in order to keep the know-how, in order to have the unique rights for this kind of substance. If possible, you should retain your know-how and maintain another barrier, another border for your competitors who might want to use that or steal that. So it's very important to have an application for a patent. Think about it very carefully. Prevent your competitors from using the data. So in the information published in patent applications, that includes funding, resources, effort to protect their best and most important developments. How can we understand where our competitors stand in this case? Is it possible to find out whether something like that has already been patented? Well, of course, you can do that. That's easy. You do a research among what has been patented so far. There are certain applications, software that help you analyze the data. This kind of research is called the patent landscape. And we can select all the inventions, and these companies can select inventions that have something in common with what you are developing and make a report on the countries where such things are patented, the types of products that are available on the market, and so on. So the technical domain you are operating in is also of great importance because that may include information where you can find partners to present your product on the market. What is the difference between patent cleanliness and patentability? Is it the same or are those different things? Yeah, patentability are the conditions which serve the basis for making decision about patentability. You need to know whether this is a novel solution and whether it is not obvious to the technical specialists from the relative respective domain. You can make a research, you can find out whether it has been published. You need to find out whether some amendments, some changes have to be made into this technical solution. So all these have to be considered when making an assessment of patentability. As for patent cleanliness, it's about the patents that can prevent you from launching a product on a certain market of a certain country. That may establish a monopoly for a certain product in a certain country. So the patent owners of a similar product may prevent, or just availability of a similar patent may prevent you from launching a certain product in a certain country. Is it possible to obtain a global patent? No, I'm afraid not. Unfortunately, there are patents that embrace the CIS countries. There is a European patent which basically embraces the majority of European countries. However, there are specific things that you have to know. But as a rule, the patent is valid for the country where it was obtained. In order to obtain a patent in a certain country, you need to find out whether other patents have been challenged in this country. So you need to study the patent landscape, so to speak. You will need to find out when you can launch a certain product or whether you should change the strategy of launching products on a certain market. Maybe you need to change the strategy. Thank you so much, Marina. We have a lot of questions in the chat, a lot of specific questions. So now, within an hour, we are doing our best to embrace as many questions as possible. I think we should devote some time to assessment, why we need an assessment. I will do my best to fit into the schedule the time frame for registering a trademark. First of all, I would like to thank Ross Patent for speeding up, and today the procedure takes from 7 to 8 months from the date of application until the expertise. 1 month is the formal expertise, and 6 months is allocated for consideration. So on average, that's going to be 7 or 8 months until the decision is made, the conclusion is drawn. 7 or 8 months if we are not talking about requests. Otherwise, if there are certain specific requests from third parties, from the state authorities, that can be quite complicated, and that could bring you into trouble. So first you send an application, and if a similar application is filed after your application has been sent, that's okay, and you will be the first, and you will be kind of blocking the opportunity for other companies to obtain a patent for a similar thing. You are welcome to ask us questions, to send us your questions. We will be happy to answer them. Let us talk a bit more about the assessment. Why do we need to make an assessment of intellectual property? Of course, that's an intangible asset. Here we are registering a trademark, we're obtaining a patent, and that's cool. And most often, the accounting department does not register any intangible assets because it's not EMA as they believe. They are basing their decisions on different things. So within the framework of this cost, we calculate the cost of our EMA, and I believe that the cost-based calculations is not the best way to assess a company or a product. So we highly recommend you to assess your EMA at minimum in terms of the comparative approach. Why do you need this kind of assessment? First of all, to commercialize your intellectual property or object. When we create a franchise, when we register an object of intellectual property, we need to know the royalty. If we end up filing a lawsuit, and we are seeking a compensation, it's very important to know the worth of the intangible assets, and we can calculate the damage. That deals with the capitalization of the business. The more expensive your assets are, the more expensive your business is. So this kind of assessment has a very positive impact on the project's If you want to attract investors, or venture capital, so this kind of assessment will be quite attractive for your future investors. You should also bear in mind that if you have intangible assets, that's a quite nice instrument for you to borrow funds from banks, from investors. So in a bank, your intangible asset can serve a very nice pledge. A good assessment that assesses your intangible assets as, for example, 500,000 rubles, you can borrow 500 rubles in a bank as a loan. Thank you so much. Let's talk about Skolkovo legal toolkit. In terms of intellectual property, we deal with legal issues. We deal with the legal entities and obtaining the residential status in Skolkovo. This is a free of charge program developed in Skolkovo to help entrepreneurs, startups, and innovation corporations in legal issues. We also assist in capitalization. It can be your company can be any kind of company, a joint venture, an LLC, anything, PLC. So this kind of complex support is included in our legal toolkit. We do the due diligence. We check the form of registration of your company. We look at the options of selling the rights and goods and services. We check this very thoroughly. We can also offer services on a monthly basis. Your first request is kind of free, is quite free of charge because we are part of Skolkovo and that is funded. But if you would like to cooperate with us on a permanent basis, there are different options, and even the international patent fees can be compensated with the help of our company. For startups and clusters, we launched this kind of program. You can see it on the screen. It's a fast track program. I think this is the fastest, the quickest thing available on the market. It's only 36,000 rubles. You get support from mentors, you get support from our facilities. A very well demanded, very highly demanded and very efficient program we launched some time ago. There are a lot of other consultants on the market. They provide different quality of services. And another thing would like to mention is the fast track into the register of the domestic software. Because of that software, you will have a chance to include your software into the register of the national or domestic software. For Skolkovo participants, that's something that is provided. But if you're not a Skolkovo resident for some reason, you will need to register that on your own, so we can help you with that too. We work at a very high speed, and we have a well-developed step-by-step program what to do. This is a very nice advantage when you are applying for the state procurement programs and apply for other types of state support, because you know that any kind of support has to do with the uniqueness of the domestic software. I would like to say a few words about the support of our partners. Maybe you know that we are re-signing the agreements between the Foundation Skolkovo and our key partner. And I will say a few words about the partners. There are key partners and official partners. You can see the difference on the slide. And actually, in this case, you don't have to be necessarily a resident of Skolkovo, but we have a lot of branches in Russia. You can be part of the regional operator or registered with the regional operator. The condition for obtaining a partner status, you can see on the screen, that can be based on a permanent agreement, on a temporary agreement. We will disclose all the requirements, and you are welcome to join us. Talking about micro grants available for Skolkovo residents, they can be spent on the services of patent counselors. They can be spent on participation in Skolkovo. So this is a start. The startup should be the participant of Skolkovo project. It should have from 3 to 50 employees in the team, and so on. How to obtain a micro grant? You need to make an application to Skolkovo and make an agreement for the necessary services. Make an application for the micro grant, send it with all the necessary documents, and sign an agreement about allocating the micro grants. You have the links on the screen. You can find out more about it. Please remember our contact details. You are most welcome to ask us any questions, to join us, to use our services. Thank you so much for your time. If you have any questions, please put them down in the chat. We are still in Skolkovo. Today and tomorrow we will be available physically. If you need to organize a meeting on site, if you want to spend time sunbathing on the lawns, you are most welcome. We can talk about your project, provide consultancy, provide consultation. You are welcome. We are always ready to help Skolkovo residents and participants and all the companies who address us for help. We pay special attention to any kind of project, and we will do our best to help you. Thank you so much for your attention. Let's keep in touch. The Startup Village goes on.
веселья, жажда путешествий, жажда общения. Утоляй любую жажду с освежающими вкусами Липтон. Мой любимый персик.
При низких температурах окружающей среды тела быстро теряют энергию. Но нахождение вблизи источника тепла позволяет телу получать тепловое излучение. Происходит самопроизвольное перераспределение тепла. Следовательно, когда источники тепла находятся вместе, их энергия побеждает холод. Лучшее создается вместе. Газпромбанк.
МТС Стартап Хаб. Работа с реальным бизнес-заказчиком МТС. Доступ к ресурсам самого крупного телеком-бренда в России. Не можешь поверить? А в твой стартап обязательно поверят. У нас есть все, что тебе понадобится. Ресурсы, клиенты, технологии, каналы продаж. Мы оценим твой продукт, правильно применим в своем бизнесе и масштабируем на мировой рынок. МТС Стартап Хаб ждет тебя и твоих нереальных бизнес-идей.